I make that 11 o'clock, but I think I maybe wait a couple of minutes. I thought there might be a couple more people who might be attending this morning, so I'll give a couple more minutes and then we'll start the meeting. David, are you ready to record?
Yeah,
Recording, that'd be good.
just started just now.
Okay, perfect. Okay, can everyone see and hear me to start with? So nodding of heads, which is good. If you're not speaking, can you please just put yourself on mute, and that avoids any echoing and things like that while we're doing the meeting, any background noise feeding into it. So good morning and welcome everyone. I think I've met probably most of you either at the last pre-inquiry meeting or at the site inspection that I did on the 22nd of May. But for the benefit of those I haven't met yet, and for anyone watching online, my name is Trudy Craggs, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, the DPEA. This is the second pre-inquiry meeting in relation to the City of Edinburgh Council Granton Waterfront Phase 1 Compulsory Purchase Order 2023. It is a virtual meeting. It has been broadcast live, and it will be stored as part of the DPEA website archives. And as such, it will be capable of repeated viewing. By participating in this virtual meeting this morning, you are consenting to being filmed. You're also consenting to the use and storage of those images and sound recordings, and of any images or information pertaining to you contained in them, webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. And if you want any further detail on our privacy policy, that can be found on the DPA website. So if everyone's happy with that, we will continue to carry on proceeding. So quick thank you to my colleagues David Spears and Lucy Wakeman for arranging today's meeting. They're hiding in the background, but they will step in if there's any technical difficulties during the course of the meeting. So I've been appointed by the Scottish Ministers to consider the proposed order and objections to it, to hold a public inquiry if necessary, and to submit a report to the Scottish Ministers making findings of fact and recommending whether or not the order should be confirmed. So I'm joined by the Council this morning and some of those who have objected to the order. Can I first of all ask the lead participant for the Council to introduce yourself and those attending on your behalf today?
Thank you. I'm Sat Patel. I am the Council's Programme Director for Granton Waterfront Regeneration. Joining me this morning are Ros Kelly from our legal department and Graeme McGartland, who is our Head of Estates.
I think Andrew McDonald is also here.
Thank you. Sorry, I can't see him. Apologies. Andrew McDonald's also with us as well. He's also supporting Ros in his role as a solicitor for the Council.
It is difficult to keep track of people on screen, so don't worry about that at all. Often you don't see all the pictures of everyone. I'll now go through the various objectors and ask you to just introduce yourself, just so everyone can put an interface in the plot that we're speaking about. So first of all, if I'm going to plot 1, I think that's you, Mr. Jennings.
Yes, it's David Jennings. I am from Thornton's Law and I'm representing Lidl. Lidl are the owners of plot 1.
Great, thank you. I turn to plot 2. I'll maybe ask Meryl Boyd to introduce yourself.
Good morning, everyone. I'm Meryl Boyd from Terra Magna. I'm representing the Divernos on plot 2.
Mrs. Diverno is also here this morning.
I'm just
Thank you for joining us this morning. As far as I can see, Leonardo Ferreira is not here.
Morning, Ms. Craig. It's Michael Wells from Thornton's. I'm representing Mr. Ferreira.
Okay, great. Thank you for that. Are you expecting Mr. Ferreira to attend at all today, or you're just attending on his behalf?
I'm attending on his behalf. He said he might log in, but I'm authorised to have instructions to deal on his behalf. So if it doesn't appear, we can certainly proceed, and I'll report back.
Oh, that's absolutely fine. I was just checking. We weren't expecting him. That's great. He can join if he comes on, or he might be watching it on the public link.
I think that might be the case. Thanks very much.
Okay, in relation to plots 3 and 5, I think we've got Mr. Stringer here.
Yeah, Neil Stringer, Turkin-Connell, representing Delicatos for their plots there and possible tenants. So, and I think they might just be watching on the public screen as well.
Okay, that's great. That's Mr. Wojciechowski. I think he's watching online. Perfect. Okay, so that's everyone that I was expecting to be here today. So, like the last meeting, I will be keeping a note of our discussions this morning, and I will circulate a note of the meeting within a few days after this meeting for your records. So, turn to the next item on the agenda, which was the purpose of the meeting, and a reminder of my remit and the scope of any inquiry. So, I held a first pre-inquiry meeting on the 4th of April, and it was agreed at that meeting that the case should be sisted, which means put on hold, for a period to allow negotiations to continue with a view to objections being withdrawn, and that a further pre-inquiry meeting will be held at the end of that period. And that's this meeting now. This is the second pre-inquiry meeting. And the purpose is for me to get an update on the negotiations, to discuss whether any further procedure is required, and if so, to discuss and agree the procedural arrangements going forward. Similarly to the last pre-inquiry meeting, this meeting does not form part of the inquiry, so we don't discuss the merits or otherwise of the order or the objection. I don't hear any evidence or anything like that at this point. It's purely procedural. As for my remit and the scope of the procedure, any objections that relate exclusively to compensation matters would fall out with my remit, as those are matters that would be considered and determined by the Lands Tribunal if agreement's not reached and if the order is confirmed. So that's not something we discuss or go into as part of this process. It's a separate process that would be taken forward if agreement isn't reached. So we'll probably come on to that a little bit later when we look at potential participants if we need to go to an inquiry session, but just keep that in mind. Purely compensation is not this forum. That would be a different forum if agreement isn't reached. Okay, so an update on negotiations. I asked the council to provide me with this last week, which they did. Thank you very much for that. It was very helpful. Just to summarise my understanding and to get the objectors' understanding to make sure we're all in agreement as to where things currently stand. I'll go through the various plots. So in relation to plot 1, my understanding is that the servitude negotiations are ongoing with National Galleries of Scotland, and it's anticipated that an unconditional missive will be in place by the end of June, maybe early July, with the servitude being completed shortly thereafter. So, Mr. Jennings, does that kind of accord with your understanding from where matters are at the moment?
I think the timescale is probably a little tight for us. You're absolutely right. The negotiations are ongoing. Lidl have a process which involves sign-off following reports, and that does tend to take 3 weeks after agreement has been reached. So that really leaves us just a pretty short amount of time to achieve it within that timescale.
Okay, so it might be early mid-July to allow your clients time for sign-off.
Well, to allow time for sign-off, working back 3 weeks from then, it really takes us to the middle of June. So that really means that if we're going to agree it would be within the next couple of weeks, which is possible, but in my view, not realistic. I think it's more likely that it would take 4 to 5 weeks from now, which does take us to the beginning of July, but I still have my reporting and sign off after that, which adds another 3 weeks.
Okay, thank you for that. Does anyone from the council want to come in and say anything on that, or are you happy that I go on to the next objector?
Rose, do you have anything that you want to add to that?
No, happy with that.
Okay, so in relation to plot 2, my understanding is that the objections in relation to this plot, both from the tenants and the owner, relate to compensation matters. And I understand that the district valuer has visited both Leo's garage and the laundry, Arnie Laundry, which are both parts of plot 2, which are owned by the Invernos. And I understand he awaits further information at this point in time to obviously assess the compensation claim. Is that looking at Ms. Boyle and Mrs. Inverno, is that your understanding of where matters lie at the moment?
Yes, I met when I was with Kate Payton when she met at the site at the end of April. We've completed the valuation report that went to Kate Payton last week. She's reviewing that, and I'm going to put forward a full claim. And then we've got another meeting proposed for the 13th of June to take matters forward.
Okay, that's really helpful. Again, anyone from the council want to comment on that? Anything to add to that?
I would just say that was the update I would have given, because I heard that Kate was in touch to give us that update yesterday. So.
Okay, that's good because matters are moving. In relation to plots 3 and 5, again, these objections in the main relate to compensation matters. And again, I understand the district value visited the properties at the end of April. And I think Shepherds are doing a valuation for your clients, and that may or may not have been sent to the district value. I'm not aware of that at this point in time.
I'm in the dark about whether they have received the Shepherds valuation. I've not seen obviously Kate's valuation, so that's really what we need to see. I spoke briefly to Andrew McDonald this morning, and he thought maybe Shepherds had been in touch with Kate Payton, which is really what we need to find out. And we had a good meeting with the council on the 18th of April just to discuss some of the process and what we've talked about in agreement before, which really informs the compensation. So I think we need to follow up on that, Andrew and Roz. That's the one thing we had to do. I would like to think we can do something in the next couple of weeks about that, but getting the valuations are essential.
And again, from the council's perspective, does that reflect your understanding?
So Mr. Delicato has been in touch with Kate, the district valuer, just to confirm what Shepherds' fee will be to carry out the valuation, and asking for us to give an undertaking that we'll cover that, which we will go back and do so today. So hopefully that will allow the valuation to take place.
Thank you, Andrea.
Okay, that's really helpful. It's good to see that matters have progressed since the last pre-inquiry meeting. Again, if there's any further progress or any objections are withdrawn, if you can just let the case officer know, that would be really helpful. Okay, moving on to item 4. This is looking for an update on the planning application. Now, the last pre-inquiry meeting, the council indicated that the plan was it'd be submitted round about early June, and I just wondered if it has been submitted, and if not, what the current timescales are.
Thanks. Yes, it's going to be submitted on the 14th of June. So we're just working our way through that process at the moment. Some of it's been uploaded to the planning portal already, but it's a huge planning application, so it's working its way through. It should go live on the planning portal on the 14th of June. As part of the planning application, we actually have to write to the landowners and who form part of the CPO process effectively. So that those letters will go out early next week, informing them of the planning application and further details around the planning link, etc.
Okay, thanks for that. Again, there's been some progress on that too. Okay, so turn to item 5 on the agenda, which is the participation in the inquiry. So, as discussed at the last meeting, my view is that all but 2 of the objections exclusively relate to compensation matters. And the compensation matters would include the timing of the acquisition of land, should the order be confirmed and then implemented, because that's not a matter of my control, but it is something that would inform compensation payments. So objections that have made that point about the timing of the acquisition, that can be encompassed as part of a compensation claim. So the objection from Lidl raises issues that are not compensation matters, and the one on behalf of the Delicatos touches on errors or omissions within the compulsory purchase order, but the rest of it relates to compensation. And I think that was broadly the position that was agreed at the last meeting on the status of the various objections. So that being the case, and given my remit, which is not about compensation matters, my view is that Lidl would be entitled to participate in any further procedure. And for the Delicatos, I don't think I would need any further procedure on the errors or omissions that you've raised. But I'll let you come in and comment on that. As for the other objectors who have raised purely compensation matters, your discussions with the district valuer and the council can, of course, continue in parallel. That's a separate process. And as I said, you would either reach agreement on the compensation if the order was confirmed and then implemented, or alternatively, you can't reach compensation. It may be that you go to the Lands Tribunal to reach agreement on that. So that can still happen in parallel as a different process. And I would focus on the actual objection to the compulsory purchase order itself, and that would be Lidl going to further procedure and nothing further required in relation to the Delicatos. So I'll come back to Lidl in a minute. Are the other parties content with what I've outlined there?
Yeah, I better get final sign off on that. But yeah, I mean, I would agree with that, because I think that whatever any errors there are, they will be actually superseded by a part of the compensation claim. And when we have this valuation in, I think it'll all be addressed. So I think that I'm comfortable with that position.
And the other parties, if I go round to see if I can get views. Ms. Boyd or Mrs. DeVerne, are you happy that I'm suggesting that your objection is purely compensation?
Yes, I agree, and hopefully we'll continue to make progress with the district valuer in the next few weeks.
Great. And Mr. Wells, are you happy that I've categorised your client's objection as a compensation matter?
Yes, likewise, the position's the same. We're hopeful about discussions continuing in the next couple of weeks to that end.
Okay, great. Okay, so turn to Lidl. Lidl is entitled to be heard at inquiry session, but if as we discussed last time, parties that are in agreement, I could do a hearing session or I could do further written submissions. I think at the last pre-inquiry meeting, we discussed this a bit more, and between the council and Lidl, the general feeling that it should be a less formal process and probably a hearing session would be sufficient in this case. So just as a reminder, the hearing sessions is a form of structured discussion between the parties, which I lead as the reporter. There's no formal leading or cross-examination. I issue agenda normally at least a week before the hearing session with specific questions or topics that we want to discuss, and the discussion focuses on those matters in the agenda. There's no need for legal representation, but parties' lawyers can take part in the discussion. That's absolutely fine. And as we said, it's generally a less informal process than an inquiry session. Written submissions, on the other hand, is where I would invite parties to expand or clarify their evidence in writing. I may ask specific questions or just a general update on your objection. There'd be an exchange of further written submissions, and then the other party gets to comment on the other party's submission. And that would take a process of probably 3 weeks for the first submission and then probably 14 days to respond to the other party's submission. Given the state of negotiations between Lidl, National Energy Scotland and the council, I just wanted parties' views from the council and Lidl as to whether you still think a hearing would be required, or whether you feel something that could be dealt with by further written submissions. So given that it is the objector's entitlement to have a hearing, I'll ask Mr. Jennings for your view on the matters first.
I'm afraid I'm rather unfamiliar with the CPO process. Scott Milne, as you know, dealt with it last time, but he's away at the moment. I wonder, does a decision have to be made on this today, or is it possible that it could be perhaps a week from now?
What do you want that week for? Just to think about it, or to speak to your clients, or
just both of those things. To speak with Scott if he is available. I suspect that our agreement will be that the hearing session would be fine. That's my inclination, and I think that's what we generally talked about last week, but last meeting. So I suspect that would be fine. But it would be great if it doesn't have to be written in stone today.
Okay, and I'd like to get to a point where, and possibly we could do that next week, where we know what the process is going forward. Because also I've got a duty to ministers to progress the case efficiently. And we've already assisted for a period of time, so it would be good to get a date in for a hearing session if that's what we want to do, just so we can keep making progress. And if during the period between now and that hearing date, the objection is withdrawn and you get your agreement and your servitude, the hearing would just be cancelled. It doesn't have to go ahead if that happens. What's the council's view on further procedure?
Do you want me to answer that, Sat? Yeah, I think a full inquiry, I don't think that's needed. So it would really be between a hearing and written submissions. And I think preferably the preference would be written submissions. Just looking at the nature of the objections, but equally would be happy with a hearing if that's what Lidl would prefer as well. But hopefully it won't come to that and we'll reach agreement before that date's set. But either a hearing or written submissions.
So, Jennings, do you want to say anything more?
Ideally, as I say, this doesn't have to be decided today. If it does have to be decided today, I am of the same view as Rosalind Kelly, that I think it can probably be done by either of those methods. I don't think we need any really formal process in this.
Okay, so I would remind us to either. I don't think it needs a formal inquiry session at all. Mr. Jennings, I'd be happy to give you to maybe the start of next week to come back and
Yeah,
confirm.
no, that's fine. It's not going to take me longer than that. That's fine.
And then I can send out the note of this meeting after that with all the details firmed up. Although it's good that you're happy both parties for a hearing or further written submissions, so no need for a formal inquiry for this one. If we do go to a hearing session, I'd indicated in the agenda that I will be looking to hold it week commencing 22nd of July. Now I appreciate that maybe puts pressure on the agreement process for the servitude, given what you've outlined for the 3-week sign-off. Are parties available that week? Mr. Jennings?
I am available. I think Scott Milne is available that week. So yes.
And Ms. Kelly, for the councillor, are your team available that week?
I'm certainly available. I think Graham's available. Sat, I think you were unavailable.
I'm not available. Yeah, I'm not available, but I don't think I'm pivotal to those conversations. So I think if they can still go ahead with Ros and Graham without me, then that's absolutely fine.
To build in a bit more time to allow your agreement and your sign-off in the hope that you do get the objection withdrawn, I'd be happy to do it at the end of that week to kind of maximise the time that you've got. So I could suggest the Thursday or the Friday that week, probably the Thursday. Never very good to do things on Friday. Possibly the Thursday.
Okay.
I don't think it would take any more than 2 hours, to be honest. And it would be a virtual session like this. And obviously there'd be an agenda which I put out beforehand. We'd probably start at 10 o'clock in the morning, and I think we'd be finished, before lunchtime. So subject to your confirmation, Mr. Jennings, that you're happy we could go ahead with the hearing with those dates. That would give you time, hopefully, to reach agreement if you think that's where we're getting to, but equally it allows me to kind of continue progressing the case. So that would be probably my preference. Going to a hearing, make sure everyone's on mute, just I'm conscious of a wee bit of feedback. That's a bit better. There are a number of exchanges that need to take place before the hearing. So there needs to be a hearing statement and any documents that you're going to rely on. And I was suggested they're submitted the week commencing the 8th of July. And again, I'll put the date in. It would match if the hearing's on a Thursday, the documents would be submitted on a Thursday as well. I'll put the date in for that. And the hearing statement should set out fully the details of your case. So it's kind of amplifying your objection, list any documents that you want to refer to, and list those who will be taking part in the hearing, what matters they're likely to address, and the relevant qualifications. If anyone's not sure about what is required, then please contact the case officer. I'm sure they can give you a steer as to maybe other hearing statements and other cases, things like that. If you're not quite sure, they will give you a wee bit of assistance on that. I would issue the agenda week commencing the 15th of July, which again would give you time to prepare for the hearing, and then we'd have the hearing the week after. For further written submissions, if it was thought that was the preference, Mr. Jennings, from your party's perspective, I would set out in the note of the meeting the matters that I want further information on. As I said, it would be 3 weeks from that date to respond to that, and then parties have 2 weeks to comment on each other's submissions, which again would take us to probably mid-July. And at the end of that process, that's the end of, I suppose, the evidence. and the same at the end of the hearing. I would then proceed after that to finalise my report and issue that to ministers, and then it's up to ministers to make the decision at that point. Does that sound okay, Mr. Jennings and Ms. Kelly? As a general outline of timescales, subject to Mr. Jennings just confirming next week that it's either the hearing or the written submissions or either.
That's understood. Obviously, I've outlined that I think it's very tight as far as getting sign off of the documentation, which I think would be both of our preferred routes. So I think it's tight, but yes. Otherwise, understood.
I am conscious that we want to keep the case going. I don't want to put parties to kind of unnecessary expense, if they don't have to. We could push it back if my IT team have got capacity in either the last week of July or the first week in August. But I'd be keen not to indefinitely move this. Because from my perspective, ministers have an expectation of me that we do progress the cases and we do issue reports back to ministers. So I could look at those dates from an IT perspective. If people are available either the week commencing, that'd be the 29th of July, or the first week into August.
Anything like that would be I think helpful. I just think it would probably avoid that process if we can get there.
Okay, I will look at our availability and we'd work back from that. So the agenda would be 1 week before that, and issuing statements kind of like 2 weeks before that. So I can look at that and we can maybe just push it back that 1 week, which may just give people a bit more breathing space to try and get everything done. If that suits council too from an availability perspective.
Yeah, I think that's fine from our perspective. Is that all right with you, Zach, as regards time?
That's absolutely fine. Thanks, Ros.
Okay, so Mr. Jennings, if you can confirm next week preference, and I can confirm on the back of that we've got, I can do that actually this week, that we have got capacity for that week or the week after. And then kind of the timescales you're working towards. And I would set all this out in the note of the meeting, so you know the deadlines for submitting all the evidence beforehand.
Okay, thank you.
Okay. Going to a hearing, all of the material connected with the case needs to be placed on deposit by the council. I'm sure you just have that at the council offices. I think that's what you normally do. You need to include the documentation that comes in as part of this process as well, so the hearing statements and documents. I need to ensure it's kept up to date. So at the council office is the most obvious place to have this on public deposit.
Sorry, were you asking the question whether that was the place we would? Yeah, sorry. Yes, that's right. Yep.
And is that Waverley Court?
Yep.
So, Mr. Jennings, when you're submitting your documentation, and the same for the council, wherever practical, can you make sure they come in a Word compatible format? They will be submitted to the case officer, and you send a copy to the council at the same time. And equally, the council, when they submit their stuff, will copy you in, and the council will use that to build up the deposit set that's at Waverley Court. Are you happy that all exchanges are done electronically?
I am, yes.
Council happy with that? Yeah, good. Okay, and obviously we publish all of the documentation on our website. And I had a link to that website in the last note of the last pre-inquiry meeting. Any queries, please contact Jane Anderson, who's the case officer, and again, her contact details were in the last note. I'll put into this note as well, just so it's easy to find. Although I think you'll have all been in contact with her and probably have her email details anyway. And as I said, I will prepare a note of this meeting and it will go out probably next week once we get confirmation of exactly what we're doing, and I will check the dates on our capacity for a first meeting the 2 weeks after I've suggested, just to add in a bit more time to the process. Because I think if we can avoid doing hearing and parties can reach agreement, then that's also the most preferable outcome. Okay, are there any issues or matters any party wants to raise this morning? That's open to anyone, not just Lizzle and the council. So any questions or anything anyone wants to raise as part of this process? If anyone's not sure about, feel free to ask just now. Okay, I take that as everyone's quite happy. So that was relatively short. It often is when it's a second pre-inquiry meeting. That's bringing the meeting to an end. Thank you everyone for coming along and for participating. As I say, if you have got any queries or comments, please do contact the case officer, and she'll either refer your documentation or email to me, or she'll be able to respond. And I'll be in touch with you all next week with the note of the meeting.
Thank you.
Thank you.
Thank you.
Thanks very much.